So in this video, we're going to talk about cosigners, personal guarantors in bankruptcy. So stay tuned, bankruptcy bailout buddies. Welcome, debtors and borrowers, to Bankruptcy Bailout. My name is Matt Burkus, Colorado bankruptcy and debt relief attorney. And remember, here we say that debt ruins lives, not bankruptcy. Bankruptcy is your bailout. It is your legal recourse when you can no longer pay your debt. The government's not going to bail you out, the banks aren't going to help you, but bankruptcy has always been here waiting to help you when you need it. So let's get into today's topic, which addresses cosigners, personal guarantors, and what happens in bankruptcy with those individuals. So if you're watching this video, you've probably learned that co-signing on a loan or being a personal guarantor is mostly a mistake. But first, let's talk about the difference between a cosigner and a personal guarantor. So a cosigner, think of it as a co-borrower. You are on the hook for that debt just as if you were the primary borrower. So even though the primary borrower, in your frame of reference is supposed to be making the payments, from the bank's point of view, you guys are co-debtors. And this is particularly the case with student loans. You're not guaranteeing the student loan, you are a cosigner on that student loan. And in most individual consumer debts, most of the time you are co-signing the loan and therefore becoming a co-borrower. Personal guarantees are usually more common in the business world or in the corporate world. So anyway, if you're a cosigner, that means the debt is going to be reported on your credit report just as if you borrowed it, and you're on the hook just the same as the primary borrower. Now, a personal guarantor is a little bit different. So generally speaking, you are on the hook for the debt, except that your liability isn't triggered until the primary borrower defaults or stops making the payments. So in the interim, generally speaking, a personal guarantor will not have that debt listed on their credit report because their liability has not been triggered. And the liability is only triggered for the personal guarantor when the primary borrower defaults. Now, from the practical impact of each, or the practical effect of each, is basically the same. And that is, when the primary borrower stops paying, you're both on the hook, whether you're a cosigner or a personal guarantor. So the legal effect is basically the same. But that's the difference between the two. So now let's talk about the two bankruptcy scenarios. So the first scenario is what happens when the primary borrower declares bankruptcy and what happens to the cosigner or the personal guarantor. And then the second scenario, of course, is the opposite of that. What happens when the cosigner files bankruptcy? What happens to the primary borrower? This shouldn't be too hard to figure out. If the primary borrower files bankruptcy, well, the cosigner and the personal guarantor are not on the hook. You guys are liable for that debt. There's a reason the bank needed a cosigner, and that's it. The primary borrower filed bankruptcy, so now you're on the hook, and you're not protected by the primary borrower's bankruptcy. All right, so they'll get the discharge. The primary borrower will get the benefit of the discharge, and the bank is going to come after you for the debt. And before you jump ahead to the next question, let's just address it right now. You don't really have any recourse to go back after the primary borrower for two reasons. One, as a cosigner, you don't have any recourse anyway because you're a co-borrower. And two, the primary borrower's bankruptcy wipes out any liability they may have had to you anyway. So as a personal guarantor, the law will sometimes imply that you have recourse to the primary borrower if they default. Although it's best to have a separate signed agreement making or stating that. However, in absence of that agreement, sometimes a personal guarantor can go back after it. But again, the primary borrower's bankruptcy wipes out that liability anyway. So you're just on the hook and have to pay, and there's nothing you can do about it. All right? So hopefully you've learned your lesson. And in the reverse scenario, not much really happens. It just depends on who is paying the debt. But if the cosigner or the primary borrower files bankruptcy, they wipe out the debt as to themselves, and the primary borrower is on the hook, as they are anyway. Now, if both parties file bankruptcy, then both are off the hook, and the lender goes about his merry way, collects his insurance, and goes on and lends money to somebody else. So there you have it. If you're a cosigner, okay, now you know, don't cosign alone or become a personal guarantee, especially on the individual level. It's one thing to personally guarantee a loan for a business and for a business endeavor. It's another to cosign a loan for your son or your brother or a relative or a friend. That's usually going to end badly, because think about it for a second, right? If they need a cosigner, there's a reason they need a cosigner. It's because they got crappy credit, or they don't have enough income, or there's something wrong with their situation. Why would you assume the risk when the bank isn't even willing to assume the risk, and the bank has the resources to assume the risk? You as an individual don't. So if you're going to cosign a debt, the main rule there is you better have the ability to pay that debt before you cosign, and be prepared to do so. And if not, then don't cosign the debt. Anyway, I hope this video has helped you. My name is Matt Burkus, Colorado Bankruptcy and Debt Relief Attorney. I offer free initial phone consultations to the residents of Colorado for the purposes of bankruptcy, and I also help people with back taxes and student loans. Best of luck to you.